Good morning. We've got quite a few folks over here lined up on the wall, so welcome to y'all. Chairman in front and Representative Houston. What you got?
Thank you. I'm bringing again House Bill 455. This is the Georgia Agricultural Marketing Authority, and the Georgia Agricultural Marketing Authority will oversee the farmers markets in our state, and it's very similar to the authority we have down at the fairgrounds, state fairgrounds. It's been real successful, and we hope it will revolutionize a lot of our farmers markets. If I have any questions, I'll be glad to answer them.
You have no questions.
Thank you.
Chairman McCall.
Thank you, Mr. Chairman, members of the committee. 545 is the bottom one under a modified open. Georgia's a right to farm state, and all this does is just updates the code, and it takes out a lot of unnecessary language that's in the code, and it updates it to reflect more modern practices that ag and farmers are using these days.
Chairman Fleming.
Thank you, Mr. Chairman. Chairman McCall, some of that language it takes out to modernize, does it affect one's ability to pursue a nuisance claim?
It doesn't necessarily affect it.
Affect.
Effect.
Not perfect, affect. That's what I meant to say.
It perfects it, but what it does is it brings in line, it strengthens the right to farm law in Georgia. There's some loopholes we found in other states that did result in some lawsuits that we thought were frivolous. I was worried that I was going to get a lawyer question, but I can...
we can still arrange that.
But yes, it doesn't restrict anything. If you look at it somewhere down in there, and I can't see it good enough without pulling it up close, but it doesn't restrict the ability to sue if somebody's doing something wrong, improper, or illegal.
Okay. Thank you, Mr. Chairman.
Thank you.
You have no other questions.
Thank y'all.
Mr. Reeves.
Thank you, Mr. Chairman. I'm here on House Bill 472, which is about 3/4 of the way down on the second page. This is an administration bill. It's a DFACS bill for this year. The main two things it does is help Georgia prepare for the implementation of the Federal Families First Act for next year, and also it helps better define and clarify judicial options for juvenile court judges in placing children in alternate options before they go to foster care.
You have no questions.
Thank you.
Chairman Silcox.
Thank you, Mr. Chairman. I bring to you House Bill 247. It's on the second page, about a third of the way down, House Bill 247. And this bill is brought to the House by the Prosecuting Attorneys Council and the Elder Abuse Council, and it does three things. It removes language in lines 16 through 19, since this crime against the elderly was made a felony under a bill we passed last session. On the second page, lines 41 through 43, it expands the definition of exploit to include the taking of an elderly person's resources due to mental or physical incapacity. And number 3, it allows the Department of Community Health to contract with local law enforcement to investigate potential elder abuse in unlicensed personal care homes. If I may, I have another bill, Mr. Chairman.
All right, you have no questions on that one. Go ahead.
Thank you. Also have House Bill 424. And House Bill 424 is a companion to Chairman Efstration's sex trafficking bill. And it does three things. Section 1 of the bill adds the offenses of trafficking persons for sexual servitude, keeping a place of prostitution, pimping, and pandering to the definition of potential criminal gang activities. Section 2 of the bill adds the same crimes that I listed to the offenses where complainant's past sexual behavior may be admissible into evidence. This is also called piercing the rape shield law, and the procedure for doing this is prescribed for the prosecution in lines 117 through 124. Finally, the third section of the bill corrects the effective date for the child hearsay law, because when this bill was originally passed, this language was originally passed, it was passed under a different section of the code, and this just clarifies it so that all evidence in child hearsay cases can be admitted at the time of the trial and not at the time of the offense.
You have no questions.
Thank you.
Chairman Werkhauser.
Thank you, Chairman, and welcome to the Grandfathers Club. On the first page, 3/4 of the way down, House Bill 373 is the Department of Labor's request to keep it in compliance with the federal government. They require that our employees have background checks if they're going to access federal records. This bill actually passed both chambers and made it all the way to the governor's desk, only to be vetoed because our friends across the hall had an amendment attached to it that caused problems. We'll try to prevent that this year.
You have no questions.
Thank you.
Chairman Petrie.
Thank you, Mr. Chairman, members of the committee. Today I bring to you House Bill 501. House Bill 501 would create an opportunity for the mariculture or the farming of oysters in Georgia. This is supported by the Department of Natural Resources, this bill, and the Department of Agriculture, and passed unanimously out of Game, Fish, and Parks Committee.
You have no questions.
Okay, and Mr. Chairman, if I could mention one other, House Bill 1 at the top of your list is a bill that would change the a very important scholarship in this state, the Georgia Special Needs Scholarship, would change the name to the Senator Eric Johnson Scholarship. Thank you, Mr. Chairman.
You have no questions. Chairman Dollar.
Thank you, Chairman. HB 342 found on the second page under modified structure. Pardon me? HB 342. When a car is pulled over for a vehicle infraction, like a tag sticker, tail light out, headlight out, currently the ticket has to be given to the driver. What this will authorize law enforcement to give that ticket to the owner of the vehicle if they're not driving the car. They don't have to. This just authorizes them the ability to.
You have no questions.
Thank you.
Representative Walensky.
Thank you, Mr. Chairman. I present to you all today House Bill 507. It's on the third page. It's the last bill on your sheet. The purpose of this bill is to fix a minor issue with House Bill 196 that passed last year. The intent of House Bill 196 was to allow commercial property landowners to submit to the county tax assessors income and expense data because tax assessors were not properly evaluating that information. This does a minor fix by changing the word utilized to considered and fixing the conjunction to give this bill the intent that House Bill 196 was supposed to enforce.
Chairman Fleming.
Thank you, Mr. Chairman. I was trying to figure out what you said this bill does.
Thank you, Chairman.
Can you give it to me one more time in easier language?
Yes. So House Bill 196 made it where landowners of commercial properties could voluntarily submit to a tax assessor in the county their income and expense data. That wasn't allowed before. A lot of times the tax assessors would make an evaluation and there would be no income and expense data. And then the landlord couldn't submit it to them. So that's what that bill did. However, by using the word utilized instead of considered, utilizing the income approach, The tax assessors, especially in DeKalb County and some other counties, felt that the income approach was the only approach they could use because they had to utilize it and couldn't consider other approaches. This bill allows them to consider everything as a whole, even the data submitted.
So giving more options to the assessor to decide the value of the property by utilizing different ways of analysis.
Yes, because under House Bill 186, they were reading it, they were stuck just to the income approach, and they couldn't consider everything beyond that. Thank you,
Thank you, sir. Appreciate it.
Bruce Williamson.
To the author of the bill, we want to clarify that the landlord is authorized to give, they have to be willing to give that information. They're not mandated to give that information, correct?
Correct. And yes, they only give it if they want to voluntarily submit it to the tax assessor.
Chairman Knight.
Thank you, Mr. Chairman. I appreciate the gentleman bringing the bill. I hope this will fix the problem. However, I think we'll probably be back in some way because it seems that the tax assessors will interpret the code any way that they want to.
Thank you, Chairman.
I'm sure the gentleman knows of what he speaks. You have no other questions.
Thank you.
Representative Hogan. And I promise you that Whip Kelly will not ask you any questions.
Thank you, Mr. Chairman and members of the committee. I bring before you today under modified structure on the second page 445. This is a bill that's desperately needed for the coast of Georgia. The last time this bill was looked at was in the 70s by Representative Reed Harris, who represented the Brunswick area at that time. HB 445 amends the Shore Protection Act passed in 1979 to protect the sand sharing system in Georgia's barrier islands. In doing so, it protects upward property and important habitat and provides recreation. This amendment does the following: changes the name of the permitting issue authority to committee, Shore Protection Committee throughout. Certifies the definition of a dynamic dune field to provide greater protection of the sand sharing system, and that's in line 13 through 38. And it defines a minor activity, and then that's in line 39 to 45. Redefines the definition of ordinary high water mark, and that's in line 46 to 51. It excludes the law application into the backyards of property, landward of sand dunes stabilized by the protection shadow of the groin, which is permitted by and continued regulation by DNR and approved by the Corps of Engineers. Makes clear the difference between a stable and dynamic dune, line 55 through 64. The only difference between this amendment and what passed the House unanimously last year is line 84 through 88. And it passed unanimously in the House, got bogged down in the Senate over the definition, as I understand, on the sand dunes. And that's the bill, Mr. Chairman.
You have some questions, Chairman Stevens.
Thank you. Would you agree that this particular bill, the way that it's written, protects both the environment and the landowner for those on the coast?
I've gotten some questions from some landowners in Tybee that are very upset even about the 25 feet. And some environmentalists want it to go to 100 feet. It does go to 100 feet on state property, but 25 feet is the state law at this time. So 25 feet is what we think needs to be there, because these people are paying property taxes out the kazoo, and they have property rights. So that's what we're trying to protect, is the property rights and do the right by the beaches.
Chairman Smith.
Thank you, Mr. Chairman. I'm over here straight ahead this way. So could you tell us what groups support this bill in the area of Glenn County? Chamber of Commerce?
Chamber of Commerce, it's a Chamber of Commerce bill. Even though I worked very hard with DNR on it, we spent hours going over this bill to make sure that it was a proper thing to do at this time. And it really cleans up the line. 20-foot trees is what it goes to right now. And with Hurricane Matthew and Irma, there's not many of the 20-foot trees left. So we're in a desperate situation to try to clean this bill up, clean up our act on the coast.
Is it not true that I thank you for all your effort? Thank you, Mr. Chairman.
Thank you.
You have no other questions?
Thank you, Mr. Chairman.
Mr. Sings.
Thank you, Mr. Chairman. I bring before you House Bill 471. It's on the first page, modified open rules, fourth from the bottom.
All right, which one is it?
This is implied consent. This bill ensures that we take into account the Elliott decision released by the Georgia Supreme Court a few weeks ago to modify the implied consent notice that an officer reads at the roadside upon checking for a DUI offense. It takes out language that informs an individual that a breathalyzer will be not voluntarily complying with the breathalyzer will be utilized against them in court. It specifically modifies or speaks to the Elliott decision and doesn't modify further. Language was also added to speak to boating under the influence and hunting under the influence, which is again parallel language.
Chairman Administration.
Thank you, Mr. Chairman. To the author, isn't it true that following the Elliott opinion, which was released on President's Day by the Supreme Court, that currently there's a risk of evidence being suppressed at a DUI trial unless your bill is passed, and that it would be enacted upon signature by the governor? Isn't that true?
Yes, sir.
Right, thank you.
Chairman Fleming.
Thank you, Mr. Chairman. And to the author, is it not further true that when an officer pulls somebody over for a DUI, for example, we have written into our law exactly what they have to read? And after this Supreme Court case, what is currently in our law that they have to read is wrong. And your bill changes that to fix that problem. And that's why we want the governor to sign it as soon as we pass it, so the officers on the side of the road can give the right warning to drivers. Isn't that correct?
Yes, sir. As it currently stands, it would violate their Fourth Amendment rights.
Thank you.
No more questions.
Mr. Chairman, if it pleases the committee, I also have House Bill 452.
Where?
It is on the second page, modified structure rules, fifth from the bottom. This bill speaks to making sure we have as an efficient as possible process for the Department of Revenue to collect out-of-state delinquent taxes owed. It utilizes the system currently used by the Department of Families and Children's Services to allow them to, that they currently use to collect out-of-state child support. It adds the language to allow the Department of Revenue to also utilize this system to allow them to not have to do back and forth paper ballots. It doesn't modify what they can collect, what they're eligible to collect. It just modifies going from paper to a digital bank match registry for the department.
You have no questions.
Thank you.
Representative Dubnik.
Thank you, Mr. Chairman and members of the committee. I'm back before you with House Bill 287. It's at the top of the last page. This is a bill that will convert a tax deduction to a tax credit for our Georgia primary care physicians who are training primary care medical students.
You have no questions.
Thank you, Mr. Chairman and members of the committee.
Mr. Gilliard.
Good morning. Thank you, Mr. Chairman. Today I bring you House Bill 79. It's listed as the first bill on the modified structure rule. This is a bill, Mr. Chairman and members of the committee, that simply gives 202,000 Georgians that are blind citizens the opportunity to parent. Years ago, there were some parables where parents were actually having their children taken away from them because they were blind. This is an opportunity for blind parents to parent their children. It gives them a great opportunity. They have training prior to the birth, and post-birth, it gives them the opportunity to parent their children. We ask for your consideration.
You have no questions.
Thank you.
Chairman Welch.
Good morning, Mr. Chairman. Good morning, members of the Rules Committee. I bring before you two bills. One bill is House Bill 502, and the other, which is just a cleanup bill. The other bill is House Bill 311. And House Bill 311 is...
Where are they?
Trying to find, I don't see 502 on here, so I'm going to skip over that. 311 is... .311 is on the very back, along with 502.
Oh, I see it now.
Mr. Chairman, if you will, out of the two bills, the most
We had
important-
this discussion before.
We didn't. I said I would come back the next day, so should I do that today?
No, I think while you're here.
311 is a waiver of sovereign immunity. This is actually an extremely important bit of legislation for every citizen in the state of Georgia. Currently, individual citizens cannot seek redress as to the constitutionality or legality of a statute or a local ordinance. So in order for citizens to be able to sue and to challenge the constitutionality of a local ordinance or a statute or the application of a rule or regulation, we need to waive sovereign immunity. Our Constitution requires that the General Assembly waive sovereign immunity. In doing so, what you're doing is opening up the courthouse doors to allow for those actions. This is a very good government bill. It is significant and necessary, and it is the result of a series of Georgia Supreme Court decisions that have worked to close, if you will, our avenue for citizens to get to court. It's incumbent upon us as the General Assembly to open those doors back up. And that's essentially what this bill does in a very limited and narrow fashion. And then House Bill 502 is just a language cleanup bill, very, very simple.
Chairman Fleming.
Thank you, Mr. Chairman. Chairman Welch, on House Bill 311, I think what I understood you to say is that right now when the government does something wrong, it's hard to sue them, but you're going to fix that?
That's correct.
Okay, thank you.
Mr. Beverly.
Thank you, Chairman. Gentleman Yield.
Yes.
Will this apply to state agencies as well, or is it just municipalities? Would it be agencies as well?
It applies to state actors as well, so it applies to both. There are, under the APA, there is an avenue for filing for declaratory relief and a stay on the implementation of a rule, or if a rule is deemed to be inconsistent with a statute. Aside from that, however, if we adopt a law, the only way that can be challenged in terms of the constitutionality of a statute we adopt is if two parties come into conflict over that law and sue. This would actually allow for now there to be a direct challenge to the adoption of the law, so that citizens can do that before they ever get into a bind underneath a law they believe to be unconstitutional.
Just as a quick follow-up,
Yes.
so it'll go to authorities like school boards,
Does
water.
not.
It will not go to authorities.
It only goes to political subdivisions, counties, consolidated governments, cities, and then the state itself and its agencies.
Thank you.
Chairman Knight.
Thank you, Mr. Chairman. To my friend, is this a job security bill for the attorneys? No, I'm just.
No, it's a good.
I do jest. But could you give us an example of that may help with the bill, an example of why this is needed so that we could further understand, if we're not an attorney, a real-life example of this.
So under the decision, I think it was 3 years ago, the decision of Lathrop versus Deal, in that decision, the Supreme Court looked at the sovereign immunity provision of the Georgia Constitution under Article 1, Section 2, Paragraph 9, which says that only that sovereign immunity is not waived unless the General Assembly says it is, and allows for the enactment of the Tort Claims Act. Under that decision, Justice Blackwell found that there had not been a waiver to challenge the constitutionality of a law that we had passed. Governor Deal was sued in his official capacity, along with another agency head in their official capacity, and the court said there is no waiver of sovereign immunity to challenge the constitutionality of that law, even though they were suing Governor Deal for enacting the law, signing the law into existence. The only way, the court said, that one could sue on the constitutionality of a law would be to sue the member in his individual capacity. So this means for Governor Deal at the time, or for Governor Kemp, or for any member of your city council, or for any member of your board of commissioners, in order to challenge that local ordinance or challenge that state law, you have to sue the members individually in any effect they take to implement the law. And that means that they're now placed in their individual capacity. So like us as members, there would be no insurance coverage for us unless you had bought special insurance coverage for you politically. That means that all of our local elected officials would be subject to a personal lawsuit against them individually, requiring that they would have to pay their attorney's fees to defend the lawsuit. If we pass this legislation, all of those types of suits then fall under an official immunity capacity or an official capacity, and there would be insurance coverage for them. So this is extremely important to protecting those that are in those public servants across our state from individual lawsuits, and that's based upon the ruling of the Supreme Court. Back to your first question, though.
No, he doesn't need that answered.
Okay.
Chairman Fleming.
Chairman Welch, what you just said is that if you need to sue the government, your bill lets you sue the government. Isn't that right?
It does.
Okay, good. Thank you.
Anyone else brave enough to ask a question? Mr. Hawkins.
So if I understand you right, if the city or municipality, county, would be responsible for maintaining, say, their roads, and if they know there's a problem missing manhole cover and they're aware someone tears a car up, then they would be responsible for the repairs of that car?
That's current law already, so that you can take legal action for the failure to maintain a road after the city's been given notice, and that would be a negligence claim, a tort claim.
Really? Well, someone needs to tell the city of Atlanta, because they say it's not. They're not responsible.
This is only based on the concept of challenging the constitutionality or the legality of an ordinance. So a city adopts an ordinance that's contrary to a law that we pass. In that case, this would provide that avenue to challenge that law without having to sue the members of the city council individually. The same is true on the state level. We don't have that door. Those doors were closed by the recent decisions of the Supreme Court.
You have no other questions.
Thank you, Mr. Chairman. Thank you, members of the Rules Committee.
Mr. Williams.
Good morning, Mr. Chairman, members of the committee. On the first page, HB 12, this was HB 655 last year. It passed through the House, passed through the Senate, and it died on sine die. This is again the bill that has the schools put signs in the hallways and in conspicuous areas for the children that it's okay to tell, it's not okay to be bullied or hurt or abused, and it's encouraging them to call for help.
You have no questions. You have no question.
Oh, okay. Also, House Bill number 93, five down on the first page. This deals with the coal ash, dewatering at the coal ash plants. This was a compromise bill between Georgia Power, dealing with the dewatering of the coal ash ponds at their coal ash sites. Passed through subcommittee and committee.
You have no questions.
Further down, House Bill 218, education eligibility requirements to receive the Hope Scholarship as a Zell Miller Scholarship Scholar. What this does is extends the time period from 7 years to 10 years for someone to draw the Hope Scholarship so that they may complete their education. It also outlines that if you're serving in the military, that the military time does not count against that 10 years, and it's a good bill.
By implication, does that mean the rest of them weren't?
I can't. I'm sorry, I couldn't hear you, sir.
It doesn't matter.
Okay.
Mr. Ridley.
Thanks, sir.
Good morning. I bring House Bill 101. It's on the second page, the first bill under structured rules. And what this is, we're changing the definition of ATV, or all-terrain vehicle. There was some confusion about the language that was in there before, and it had some of the local entities that collect inventory tax charging inventory tax on certain ATVs, but not other ones. So what we've done, we just did away with the definition that was the older definition and put it all under one. And that's all the bill does.
Chairman Fleming.
Thank you, Mr. Chairman. Representative, I know my town has had some trouble with folks, particularly young people, driving these on the streets, and been some accidents.
Yes, sir.
And so what they've done is implemented some guidelines of who can drive and where. This is not going to affect their ability to do that in any way, is it?
No, sir. This right here only has to do with the ATV, all-terrain dealers, and
Just
the way
dealers.
the inventory tax is described.
Okay, nothing to do with the operation where?
No, sir.
Okay, thank you so much.
All right, thank you.
You have no other questions.
Thank you.
Mr. Holcomb.
Thank you, Mr. Chairman, members of the committee. I present to you House Bill 230. It's on the first page under modified open rule, just below halfway down the page. And what this bill does is it would allow Georgia to have benefit corporations. It's a corporate structure that's allowed in 33 states in the District of Columbia. There are entrepreneurs in Georgia who want to incorporate as benefit corporations but have to do so elsewhere. And the language of this bill was drafted by the corporate section of the State Bar of Georgia.
You have no questions.
Thank you.
Ms. Moore.
Thank you, Chairman and committee members. I'm presenting a bill on the last page. Second bill down, HB 379. This is a bill to revise the annual reporting date that cities and counties have to report their SPLOST revenues. It simply changes the law from a current one-size-fits-all reporting date of December 31st and changes it to 180 days after the fiscal year ends for each city and county, which can vary throughout the calendar year.
You have no questions.
Thank you.
Mr. Wilkerson.
Thank you, Mr. Chairman, members of the committee. Today I bring to you House Bill 174. It is on the first page under modified open rule, about halfway down. This bill passed through motor vehicles, and what it does is currently, under current law, license plate frames are illegal in the state of Georgia. So in the mail the other day, I received the Atlanta United tag, and license plate frame, and that is illegal because it cannot cover anything at all on your tag. So what this bill would do is it would clarify that to say, as long as you can read the numbers and as long as you can read the revalidation sticker, then you would be legal to drive on the road. That's all this bill does, and I would take any questions.
You have no questions.
Thank you.
What? Representative Rich.
Thank you, Mr. Chairman, members of the committee. Today I bring to you House Bill 492, which is under modified structured rule on the second page. It's the second from the bottom. This bill has been requested by the Council of Magistrate Court Judges and also has the support of the realtors. It will require applications for the execution of a writ of possession be filed within 30 days of having filed or of having obtained the writ of possession. This will help the court calendars move more smoothly and not be clogged, and also will prevent landlords from using the writ of possession as a tool or a sword against the landlords.
You have no questions.
Thank you.
All right, members, and if you will, if you've already asked for your bill, don't ask for it again. Let's just get new asks. Okay, Chairman Cooper.
Thank you, Mr. Chairman. On the second page, about halfway down, I have two bills. House Bill 345. Just like the bill that would allow the state to still take away children from blind parents, we have some places across the state that are still shackling with chains women that are pregnant and women that are in labor. This bill would just correct that, and you know, they can use restraints if they have to, but they just can't use the chains, and it encourages them not to use them at all. It's for respect for pregnancy, and so not to do things that would encourage miscarriages. On House Bill 346 is a bill to prohibit retaliation by slum landlords. What people do now is that if poor people that are living in mold with rats and insects, if they complain to the landlord and they don't change it, and they go to code enforcement, the landlords immediately start to get rid of the tenants, and when they get rid of the tenants, then the code enforcement people drop the complaints, and it just is a cycle where more people move in and they have more complaints and they put people out on the streets. So it's a very minor start. 41 other states have similar laws and laws that are much stricter than this one. Thank you.
Whip Kelly.
Thank you, Mr. Chairman. I first want to make a motion to recommit House Bill 317 to the Judiciary Committee.
Is there a second? Any objection? So ordered.
And just real quick, Mr. Chairman, I want to put my name next to House Bill 79, Representative Gilliard's bill that creates some parity for those in our state who are blind in terms of placement for adoptions through DFACS. And then also House Bill 346, Madam Chair's bill dealing with creating a right of retaliation or a claim for retaliation for renters who are being treated unfairly.
Do you actually have a bill?
No, sir. Oh, House Bill 499, my bill too. Others before self, Mr. Chairman. Others before self. 99 would allow our EMCs to run fiber for broadband on the existing poles that they use for existing electric easements. It'll help us expand rural broadband.
Mr. Hawkins.
Thank you, Mr. Chairman. I asked for House Bill 296. It's on page 2, about midway down. This applies to the revised term of court. This was asked for by the district attorney and supported by the Superior Court of the Northeastern Circuit. And it's just a simple bill of changing terms of court. Thank you.
Mr. Williamson.
Thank you, Mr. Chairman. I ask for House Bill 406, third from the top on page 3. This bill clarifies the reporting requirements for multi-county joint development authorities where revenue sharing agreements are in place.
Chairman Tankersley.
Thank you, Mr. Chairman. I'd like to ask for House Resolution 346, and this is simply the annual road and bridge naming bill. It includes all road and bridge resolutions that have been compiled into a single bill. I ask for your favorable consideration. Thank you.
Chairman Knight.
Thank you, Mr. Chairman. House Bill 447 simply makes it clear that the refundability for the tax credit for the hurricane victims only applies to the casualty loss taxpayer, and that upon transferability, the refundability does not transfer.
Chairman Ballinger.
Thank you, Mr. Chairman. I would like to ask, fifth up from the top on the second page, House Bill 478. It rewrites the child abuse registry here in the state of Georgia.
Chairman Powell.
Thank you, Mr. Chairman. I have two bills today. Second page under modified structured. First is HB 307. This is the Abandoned Motor Vehicle Act. For 30 or so years, we've been putting Band-Aids and patches on this process so that the towing companies, when they're ordered by law enforcement to pick up vehicles, when those people don't come back to get them, refuse to pay the charges, this sets up a process through the magistrates, more streamlined process to guarantee due process. Georgia's unique that because of our Constitution that we can't do non-judicial foreclosure on these type of junks. Most of these are junks and derelicts because of the if it weren't any more, the owners would come and pay up. But it sets up that process, something that's sorely needed because it's become a public safety issue. We've got towing companies around in certain quarters of the state, especially in the metro areas where they're being ordered to pick up these vehicles off the side of the roads and such as that, and they're filling up these yards with derelicts, and they just can't, to the point of getting to be a crisis. If there's no question, second bill is House Bill 288, page 2 under modified structure. This is a bill that was asked for by the closing attorneys. It just creates a simpler process for the filing with the paperwork with the clerks. Instead of paying by the pages, this different fees, I think it's $2 or so a page. If they're filing, that they could file at a straight $25 and then extra for the plats. And what this does, this allows the closing attorneys to be able to get a grip on how much they're charging in the closing process. And I thank our whip for helping shepherd that bill for me.
Representative Rogers.
Thank you, Mr. Chairman. I'd like to put my name by HB 447, Representative Laricchia's bill with the jet fuel tax exemption, and also HB 79, Representative Gilliard's bill dealing with custody for blind parents.
Okay, we had some questions I think that I may have missed. Chairman Setzler.
Thank you, Mr. Chairman. To Chairman Powell, on the bill about the repossessions, I appreciate your explanation. What's the timeline if a car is repossessed before it's disposed of using this non-judicial process? What's the minimum timeline that could happen? How much time does someone have to get their car?
Well, right now, depending on where you are and what magistrate you're dealing with, some of these you can't even get rid of them because it just drags on. But under this new process, and if I can read this timeline, I think that they can get rid of them in somewhere close to 3 months now, as opposed to 6 months or later.
Okay, no sooner than 90 days. It's not like they can dispose of these in 30 days or something like that, is that
No,
correct?
sir. No, sir, because of dealing with the magistrates and the concern for due process. As the process goes, once they're ordered, then they've got a couple of days they have to report it to GCIC to be sure it's not a stolen vehicle. Then they've got to reach out to Revenue. They've got to send out a notice, a certified mail notice. If they don't receive that back in 10 days or so, then they have to publish it in the newspaper, hang it on the courthouse bulletin board, and pick out either general circulation newspaper or legal ads. Then they can go to the court. Then they have to send out another notice to let them know that they filed suit. Then they go through that same process again. But we've put these on a timeline at this point so that the owner or the lien holder is notified. It gives them due process to respond to the situation. And if not, then it goes into the court for a settlement to say it's been basically declared abandoned. Then they have to advertise again so they can auction off the junk. And if they can get anything near what they get that. And if not, and if there's any overages at the auction, then it goes to the Department of Revenue Unclaimed Properties Division, so that if at some point, if there was any overages, then that owner could then come and they could lay claim up to 6 months, and if not, then the towing company can.
The part of Andy Welch is being played by Alan Powell today.
Mr. Chairman, if Chairman Seltzer hadn't asked me the question, I sure wouldn't have gone into none of this.
Chairman Stevens.
Thank you, Mr. Chairman. For the coastal Georgia, I'd like to ask for Representative Hogan's 445 for the shoreline protection. Also, Representative Petrie, 501, the oyster farming bill, and 452, the department bill for Representative Saines. Lastly, 79, Representative Gilliard's bill.
Okay. Chairman Martin.
Thank you, Mr. Chairman. I'd like to ask for House Bill 89. This allows for an integrated ambulatory surgery center to come potentially located in our district. Not only for the surgery center that it would have, but it will have sports training and education, fields, medical facilities. Basically, Mr. Chairman, this is an integrated center, like it says. It'll provide world-class service to patients, high-quality training to other doctors, state-of-the-art research, and be a great overall economic impact to the state of Georgia. This also went through the committee on special committee on health care, and ask for the committee's concurrence to move that to the floor. Stand for any questions.
You have no questions. Okay, let's set the calendar. This is a supplemental calendar for today. And then we will meet tomorrow for to set the Thursday calendar. Depending on how the day goes, we may have another supplemental today, but this one's going to be pretty extensive, I think. And hold on. Doing the motion.
I usually do it after you said it.
Okay, House Bill 12 under modified open. It's on. House Bill 218 under modified open. It's on. HB 223 under modified open. HB 230 under modified open. HB 455 under modified open. It's on. HB 471. It's on. HB 499. It's on. HB 79. It's on. HB 89. It's on. HB 196. It's on. HB 342. It's on. HB 346. It's on. Sir. Do you object? Do you object? Yes, sir.
This bill and the other bill that we heard about landlords evicting folks, we were trying to find the word, and I was trying to come to, we have contracts. A landlord has a contract with the tenant. Or if there's no contract, then there's certain state law.
All right, wait just a second. We had a chance to discuss it a little while ago. Is that an objection?
Yes, sir.
Okay. All right. We have a motion to move, and we have an objection. All in favor of moving it to the House floor, raise your hand. Those opposed? It moves to the floor. HB 445. It's on. Oh, you objected? I'm sorry. HB 445. There's a motion to move it to the floor. There is objection. All in favor of moving it, raise your hand. Those opposed? It's on. HB 472. It's on. HB 287. It's on. HB 406. It's on. HB 447. It's on. And that's the supplemental calendar. Wait just a second. We've got a motion from the Vice Chair.
Mr. Chair, I'd like to move that all bills on all calendars today be limited to 1 hour debate.
All right, is there a second? All in favor, raise your hand. Opposed? It carries. And we will meet at 1 o'clock tomorrow. 1 o'clock tomorrow.